Hello, class. Welcome to the 11th session on public law, and I hope that this video finds you well, safe, and healthy. The topic for today will be the House of Lords, and I will be uploading 2 videos on this. I will start with the latest question, so you will see the notes on the screen in front of you. And this is the handout on the House of Lords, which I had uploaded last week, I think about 10 days ago, a couple of days ago. I've lost track of time, I can't remember when exactly, but the handout is 11 pages, and I'm now referring to page 1 on the House of Lords. You will see that I've put the question, and this is a 2019 Zone A question, in red. Before I read the question with you, I would urge you to be careful with anyone who tells you that the House of Lords is not part of the syllabus. That's simply not true, because if you look at the past year questions, it is true that House of Lords does not come up every year, but it is part of your syllabus because Parliament is part of your syllabus, isn't it? And Parliament is composed of both the House of Commons and the House of Lords. So sometimes an exam question on parliamentary work, if they just use the word Parliament, then you would have to consider both the House of Commons and the House of Lords. All right? So that's a different type of question. The kind of question that I am looking at with you today in this session is, if you look at where my cursor is pointing at the top, a question like this, the 2019 Zone A question, is entirely on the House of Lords alone, and it is on reform of the House of Lords. And it says, if the House of Lords did not exist, it would have to be invented. That's the first part of the question. The second part of the question says, discuss the composition. Composition means membership. That means who sits inside the House of Lords, and the powers of the House of Lords. All right? The composition and the powers of the House of Lords, and make reform proposals. So the next part of the question asks you to look at who sits in the House of Lords, what are their powers, and what reform proposals we can put forward. So the suggested approach to this question, I'm now moving down page 1, and I would divide my answer into 6 different parts. The first, I would respond to the question. So in the suggested approach, yes, if you look there, this is number 1, respond to the question. All right? So if you already know your reaction to the first part, and I've highlighted that in green, if the House of Lords did not exist, it would have to be invented. That is a view of someone. It is an opinion. I've put a question here. Do you agree with this view? If yes, why? If no, why not? Now, I would answer that I would agree. So I would say, answer in the affirmative, namely that it is true that if the House of Lords did not exist, it is indeed true. In my opinion, it would have to be invented. Now, why am I saying that? Because, and if you look where my cursor is going, the House of Lords is playing such an important role in Parliament. So I will argue in the affirmative as to the first part. The second part of the question, I've highlighted that in green, is to make reform proposals, and I will show you how to do that in a short while, and my answer will conclude by which reform proposal I prefer. My advice to you, the student, is to choose a particular model or a preferred option for reform, as that will give your answer a personal touch and a feeling that you care about the issue and you are passionate about the subject matter. So number 1, respond to the question. Number 2, the powers, role and functions of the House of Lords today. Why is it so important? Once you've done that, number 3, bottom of page 1, what is the current composition of the House of Lords? I'm going now to page 2. Number 4, what is the balance of power between the House of Lords and the House of Commons? And then I will go to the next page, number 3 at the bottom. Yes? So number 4 was the balance of power. Number 5 at the bottom of page 3 brings us to the second part, which is reform of the House of Lords. In looking at reform of the House of Lords, we need to look at, are we talking about reform of composition and or powers? And I'm just going to highlight that in red for you so that you can see that clearly. Are we talking about reform of composition and stroke or powers? And then I would look at the various reforms that have happened in the past. There have already been some, and comment on those. In fact, the first reform, and we'll put that now just so that we don't forget that. Remember, there we are. Remember the Parliament Act of 1911 and 1949. Okay, now we're going to come back to that, and I'm just going to highlight that in red. That's as much a reminder for me as it is for you. Okay, and we'll come back to that. So number 5, the second part, the reform of the House of Lords. And number 6, that brings me nicely to my conclusion. All right, so 6 parts to my answer. I now go back to page 1. Right, so we've already responded, so I'm done with number 1. Let's go on to number 2. What are the powers, the role, and the function of the House of Lords? I'm going to highlight this in red so that you can see why we're talking about it. In other words, I mentioned at the beginning that I would agree if the House of Lords did not exist. It's true, it would have to be invented. Now, why do I say this? Because of this important work that the House of Lords does, its powers, its role, its function. What does it do? A, it's a forum for debate on matters of public interest. B, it revises bills which have been brought from the House of Commons. And on this point, you can also say bills can also start in the House of Lords. An example of that was the very important Human Rights Act, which started in the House of Lords. C, public bills can start in the House of Lords, so can private member bills. D, delegated legislation is considered by the House of Lords. It's scrutinized by the House of Lords. So in a sense, A to D is legislative work of the House of Lords. But that's not the only thing that it does. It also scrutinizes the executive, E. It also does, G, select committee work. H, have deliberately crossed it out so that nobody makes that mistake. It is no longer the highest appellate court. So the appellate judicial function has now been removed, and of course there is a new Supreme Court. The 12 law lords who were in the House of Lords before were moved in the year 2007 to the new Supreme Court. What else does the House of Lords do? I, it scrutinizes the reporting of bills in order for them to be compatible with ECHR rights. So it plays a very important human rights role. And indeed, look at J, and I feel that that's really important. So let's have a color for this. I'm going to say, let's put it as blue. There we are. It acts as the constitutional guardian of the nation at the end of the day. Okay, so these are all reasons why we need the House of Lords. If it was not there, it would have to be invented, tying it back to the question. All right, so it's the constitutional guardian. Let's put that back in black. You can see I'm having fun with the colors here. I don't have a whiteboard in front of me. This is the best that I'm going to get, the closest that I'm going to get to a whiteboard. So I'll have to play with the colors instead. Number 3, current composition. Now, when I say current composition, I mean like literally now. So this is the 30th of March. Currently, there are 700 plus members. They're just under 800, yeah, so 791 was what I saw yesterday, who are eligible to take part in the work of the House of Lords. Most of them, the majority, are life peers. That means they've been appointed for life. So there are 92 hereditary peers at the moment. In 1999, the bulk of hereditary peers were removed, leaving only 92, I beg your pardon. There are 26 archbishops and bishops, and there are no more law lords. I told you the 12 have been removed. There's 600 plus life peers. The majority of them are appointed by the Queen on the recommendation of the Prime Minister or the House of Lords Appointment Commission. So that's the current composition. Now we come to number 4. This brings us to page 2, please. So what is the balance of power between the House of Lords and the House of Commons? All right. You could start off by explaining that the law which regulates this balance of power is the, oh, that's too dark, isn't it? We'll need another color. Let's put it as, is that working? No, that's not. Just give me just 1 minute. Yeah, okay. I think that's clearer for you. So we need to look at that, the Parliament Act. So that's 1, and then here as well. Okay, and then how effective have they been in doing their work? Okay, give some examples of that. For example, the Brexit session. So we'll come back to that. Considering delegated legislation. Right. Okay. Now, so let's go back to the top of page 2. So the balance of power now. So why are we talking about this? Because to tie it back to the question is about if the House of Lords did not exist, it would have to be invented. Discuss the composition and powers. You see that word, powers of the House of Lords, and make reform proposals. So we want to tell the examiner about that balance of power between the two houses. And what is the law on that balance of power? You would have to speak about these acts, the Parliament Acts of 1911 and 1949, and explain that before 1911, the House of Lords had a veto power over legislation, and how this was removed and replaced with a delaying period, maximum of 1 year for a non-money bill, and maximum of 30 days if it is a money bill. And the last time that this was actually used was this case, isn't it? Do you remember this case? The case of Jackson and AG, whereby the hunting bill was something that the House of Lords did not like. They delayed it for a maximum of 1 year, and it finally became an act nonetheless, the Hunting Act of 2003. And that was the subject of the case of Jackson. So you've explained that balance of power, and then you come to talk about this next relationship between the two houses, the legislative function, the powers related to the legislative process. All right. So why are you talking about this? Again, you're talking about the work that the House of Lords does. It reviews, it considers bills which have come from the Commons, and also bills from the House of Lords itself. Next, how effective have they been in doing this work? Why is it that we say that they are essential? Now, the reason being, the House of Lords is a revising chamber for bills. Many examples of where they have played an important part in the content and the amendment, the revision of provisions of bills must be discussed. Some very recent examples which concern Brexit in the recent 2017 to 2019 sessions in relation to this bill, which of course became an act, the European Union Notification of Withdrawal Bill, and of course the European Union Withdrawal Act, both in 2018 and in 2020. The House of Lords have played crucial roles in the amendment and content of these bills. It has also, at the bottom of page 2, considered delegated legislation. Now, this is very important because the House of Commons does not have enough time to do this. So the House of Lords reviewing delegated legislation, if you look at the top of page 3, Yes? Oh, I beg your pardon, bottom of page 2. So, on delegated legislation, Parliament makes new laws but gives the department minister the power to fill in the details. So, once that is done, then this becomes law. It needs to be checked, isn't it? Otherwise, executive will have too much power. So that is why both the houses are given the chance to, and if you look at the top of page 3, if one of the houses objects to them within 40 days, then they have to be withdrawn. The Commons have no time to debate all these regulations. The House of Lords acts as a watchdog by debating and keeping an eye on these. So you have the positive resolution procedure and also the negative resolution procedure, which the House of Lords can use. Next, the House of Lords reviewing legislation. So we come back to this. I've spoken about this before, but it is so important that you need to tell the examiner that approximately 60% of the hours of the House of Lords is used by doing this. Revising legislation, an overwhelming majority which comes from the House of Commons. Now, why do we say, what are the reasons why the Lords are effective? What are the reasons? Why is it that we say that if it's not there, if it's not there, it must be invented? Why is it so crucial? Look, please, at the following characteristics of the House of Lords. The lower profile of party loyalty, all right? Greater procedural flexibility. Why is that? Because they are not bound by techniques like the guillotine procedure, for instance, in the House of Commons. There are more crossbenchers. That crossbenchers are people who are not affiliated to any particular political party, which means that the political whip system, the dominance of a party system, is much lesser in the House of Lords, which means they are a lot more neutral. They are also much more experienced in different aspects. So there is a breadth of experience and expertise amongst the life peers. And it is the House of Lords that itself decides whether it will look at a proposed amendment. It does not have a guillotine procedure, and it is in charge of itself, and it is able to make its own decisions without being dominated by political manipulation, because nobody in the House of Lords needs to be elected to be there. Therefore, in a sense, that frees them, all right, to be able to say or do what they want, because come the next election, they're still going to be there. Okay? And then you should also refer to the convention, the Salisbury-Addison Convention, and how it affects the lawmaking power of the House of Lords. Basically, the Salisbury-Addison Convention is a convention that says that if the government of the day have already, as part of their electoral manifesto, promised something to the public, then promise something in the form of a law to the public, then the House of Lords must not resist this. The House of Lords must not have wrecking amendments on this. They must be able to allow the House of Commons to make law on what they promised. In the last couple of decades, the meaning and scope of this convention has changed in two aspects. Post-1999, it applies now to a manifesto bill introduced in the House of Lords as well as one introduced in the House of Commons, and also the original convention is something that existed, all right, just between two parties. But now the convention, the Salisbury-Addison Convention, exists to bind the entire House, not just two parties. All right? So once you've done all that, you can conclude on the first part, link what you're saying to the question. Remember the question, so if the House of Lords did not exist, would it have to be invented? Remember that first part? I'll put it in red here. Yes, my answer would be yes. It does such important work. If it was not there, we would want to invent it. It's that important. That brings me nicely to the second part, reform of the House of Lords. Now, when we talk about reform, we need to ask the question, do we want to reform the composition, that means the membership of the House of Lords, and do we want to also reform the powers of the House of Lords? Or do we only want to reform the composition? Based on whatever we said earlier, such important work is done by the House of Lords. We don't want to take their powers away, do we? Because it's a very important scrutiny chamber. It's a very important revising chamber. It's a very important guardian of the nation. I used the phrase constitutional guardian earlier. So we want to keep all that, don't we? So please understand, class, in reform, we want to keep the role and the function and the powers of the House of Lords. I'm going to repeat that. The role, the function, and the powers of the House of Lords. Let us now go to the reforms that have already taken place in the past. The first, and I've put it in red, the most important one, is the Parliament Act of 1911 and 1949. Thank you. A question. What does this reform? This reforms, does it reform the composition of the House of Lords? What does anyone think about this? Have a think. Does it reform the composition? That means the membership. Does it? No, it doesn't. It reforms, and I'm just typing that so we'll remember. It reforms the, what is it? Quickly. It reforms the, I'm going to put it in capitals here for you, powers of the House of Lords. What powers? The legislative powers. So before 1911, the House of Lords had a veto power to, stop, to block legislation. After 1911, that was replaced with a delaying power. And in 1949, it was further reduced, that delaying power. 1911 was for 2 years for a non-money bill. In 1949, that got reduced to 1 year. So that's a very important reform. Now, after that, what happened? Another very important reform happened in 1958 at the bottom of page 3. That is a reform to the, what do you think? Composition of the House of Lords, the Life Peerages Act. So if you come to page 4 now, and I look at the top. So what did the Life Peerages Act say? It allowed life peers to be appointed for the first time based on merit and injected new blood into the House of Lords. Am I right? So it allowed life peers to be appointed for the first time based on merit. So that means that in 1958, for the first time, peers could be appointed to the House of Lords instead of the old system, which is that you inherit the title. All right. So in 1958, you could still inherit the title. You could. That was only abolished in 1999. So you could still inherit the title, but for the first time, you have a system now, the Life Peerages Act, which allows for what? I'm going to put that in red so you remember. Why is that important? Why is that important? That changed the composition of the House of Lords to allow for appointed peers. And then we come to the next reform, and that is the House of Lords Act of 1999. Now, why was that very, very important? Because this was a reform undertaken by the Tony Blair government, and the Tony Blair government felt that they needed to remove hereditary peers. So they passed the House of Lords Act to remove hereditary peers from the House of Lords, but they left 92 for a temporary period. Tony Blair said that this was stage 1 of the reform process of the House of Lords, all right? He said this was stage 1 of the reform process of the House of Lords. So why get rid of the hereditary peers? Because they've got that title as a result of who their father is. So that's not democratic, is it? So it's anomalous to have this kind of system in the 20th century and 21st century now. So therefore, the hereditary peers were removed. Now, so that was stage 1. After that, the Blair government got a bit stuck with the reform and they didn't know what to do next. Now, in life, when you don't know what to do, what happens? Can anyone tell me? What happens when you don't know what to do? What happens? You ask someone. So that's the system in the UK. So the Blair government set up a commission called the Wakeham Commission, led by Lord Wakeham. And the Wakeham Commission looked at stage 2 of House of Lords reform, and they reported in 2000 and recommended a wholly or largely appointed House of Lords, if you look there. A wholly or largely appointed House of Lords with a minority elected element. So that means that what they said was you can have part of it elected, but that should be the minority. The majority keep it appointed. That's what Wakeham Commission said. Further reforms, the Constitutional Reform Act of 2005, but this is a reform which is limited because it only removed the 12 law lords and put them into the Supreme Court. It didn't do anything else. So after that, what happened? The Labour government was still in power. It was stuck for a while. So 2001 to 2007, there was a bit of a ding-dong. A white paper came out, but nobody really could agree on what were the percentages to be elected into the House of Lords and what is the percentage to be appointed into the House of Lords. So there was a stalemate and no further reform actually took place. And then we fast forward and we come to the coalition government. And that was 2010 to 2015. Again, there was a lack of consensus and nothing happened there. Which brings us to the recent controversy, and this is why this area has now become examinable again because of this. Because during the Cameron Conservative government in 2015, what happened was there was a controversy that broke out because the Cameron government wanted to come out with legislation on, if you look here, all right, on tax credits. They wanted to come out with law to cut down on tax credits to save the government some money. Now, the House of Lords was very much against this because the House of Lords felt that some marginalized communities would be detrimentally affected. So they opposed this. Now, the thing about this legislation was that it was delegated legislation. So the question became this. The Parliament Act of 1911 and 1949 removed the House of Lords veto power for legislation. Am I correct? But hang on a minute. That is only for primary legislation, isn't it? The veto power being removed. What about for secondary legislation? So this controversy highlighted a gap in the law, a lacuna, so to speak. So what happened was that the House of Lords did not want to give consent for delegated legislation. In a sense, that's exercising a veto power, isn't it? The government was forced to withdraw this legislation, and they were very upset about it. So David Cameron set up a commission led by Lord Strathclyde, and the Strathclyde report recommendations came out in 2016. At the bottom of page 4, if you look, the Strathclyde report came out in November 2016, and after this, the government had to decide. The Cameron government at first decided that they wanted to reduce the House of Lords powers with delegated legislation to remove that veto power. However, then the Theresa May government came in and she was busy with other things. Brexit came in, and of course the priority of reform with the House of Lords became lower, and they all forgot about it. So this issue is something that you can bring up, talk about the Strathclyde report recommendations, and you can see what your personal preference is. So for example, you may feel that the Parliament Act of 1911 and 1949 ought to be reformed in order to tell the House of Lords that they should not be able to block delegated legislation like this. That's what David Cameron would have argued, isn't it? I don't agree with that. I think that they should have the power to block it because it's an important checks and balance mechanism. But that's just me. I'm not sure what view you would prefer. The last proposal for reform under H is the report of the Lord Speaker in 2017. I'll put that in red as well so it's easy for you to see. And in 2017, the report of the Lord Speaker said the reform should focus on reducing the size of the House of Lords. So that reform has already been fairly successful, because in October 2017 there were 800 plus peers. As I said, today there are less than 800, so the number is slowly reducing. How is that? This is by the Prime Minister recommending less peers for recommendation, okay, to be appointed. So the reduction in numbers is hoped to be achieved to reduce the numbers to around 600, because the House of Commons has 650 members, so reduced to around 600, to be achieved within 11 years through a 2-out, 2-in system. Okay, so these are some recommendations in the 2017 report. Conclusion. So that brings us to the end of this question, and you can conclude on both parts. So do you think the House of Lords should be reformed? Well, actually before that, if you recall the first part of the question, just for you to be absolutely sure, what's my conclusion there? If the House of Lords did not exist, it would have to be invented. Do I agree? Yes. On the second part, should the House of Lords be reformed in the near future? It depends what you think. Now, so here, in terms of the size, you can say that a suggestion is for you to say that you would agree with the report of the Lord Speakers Committee, that it would be a good idea for it to be eventually reduced to around 600 to be compatible with the House of Commons. But in terms of powers here, all right, so you've got composition, size, powers. In terms of powers, my personal view is that the powers of the House of Lords should be maintained, because their invaluable function, which we spoke about just now, in terms of a revision chamber, a scrutiny mechanism, to act as a checks and balance, as the Constitution guardian. These are all things that should be maintained. So I'm not in favor of reforming the House of Lords' powers. Even with delegated legislation, I'm not in favor of reform of any powers. I believe the House of Lords performs a crucial checks and balance mechanism. In terms of composition, it would depend on what you think. So for instance, if you feel that there should be an elected element in the House of Lords, you can view that in your answer. As for me, I personally feel that the House of Lords as it is, the appointment system is working well, and it is a unique house, and the fact that the peers are appointed is what, in my opinion, allows them to do the work that they do in the manner that they do it, the neutrality, the objectivity, and their role, as I said just now, the constitutional guardian of the UK Constitution. So I would advocate that their role, their powers, their functions be maintained as it is now. Even the composition, I would say that the appointment mechanism as it is now is working fine, and it's all right if there is no elected element, because the method that the House of Lords uses, as writers like Don Oliver argues, and I've put this argument later on, for instance, on page 9 of the same handout, right? So for example, the famous, renowned constitutional lawyer and commentator Dawn Oliver, in her famous work Democracy, Parliament and Constitutional Watchdogs, she argues that it's fine to have a non-elected House of Lords. It's not undemocratic, and that it is important because it is the fact that they are not elected that allows them to do their work in a non-partisan manner. So I would agree with that, and I would finish off with that in this question. All right, so that brings us nicely to the end of the first question, and I'm now on page 5. Okay, so please look at the last thing that I've said. What is your preferred option for reform and why? So just like I said just now, give your reasons, state your preference, and you'll be fine. All right, thank you for listening. I hope this video has helped you to understand this topic of House of Lords. I will be posting another video in due course, which I hope will assist you. Thank you. Bye-bye.